you, Chair. I'm Dean Russell. I'm the Member of Parliament for Watford. And I'd like to just ask a little bit about the effectiveness with regard to Human Rights Act. I just want to get your sense from an individual perspective, whether you feel that the Human Rights Act has been effective in enabling individuals to enforce their human rights. If I may start with you, Lord Neuberger.
I think from the point of view of the courts and the justice system, the big problem about people enforcing their rights under the Human Rights Act is the same as the problem of individuals enforcing any right or defending themselves, and that is access to justice. Not merely difficulty in getting access to courts because of the cost of employing a lawyer and the really quite frightening consequences of having to represent yourself in court, because I think it's easy for a judge who spent years of his life as a barrister and then as a judge to think court is unfrightening, but for the average person it's pretty terrifying. And if you can't afford a lawyer, you either give up your rights or you have to go to court yourself. But there's an anterior problem, which is access to getting advice about your rights. And with legal aid in the present state that it is, what distresses me, and this is a general point, not about human rights only, but about everything, is the difficulty people have in getting legal advice, access to legal advice, and then access to courts. And to my mind, and this is speaking very much as a judge or an ex-judge, that is the big problem about people getting access to their rights. I can't speak more generally other than to go back to a point I made earlier, having made a negative point just now, that I do think that respect for human rights in institutions in this country, thanks to the passing of the Act and its enforcing, has meant that there is generally a respect for human rights. And when they're not observed, it's normally due to oversight rather than anything else.
Thank you. And if I may to you, Mr. Grieve, what's your thoughts on the effectiveness with regards to enabling individuals to enforce their human rights?
Again, I endorse what Lord Neuberger said. No justice system is perfect, and ours at the moment, and I certainly agree with him about this, is labouring under very considerable difficulties in respect of access to justice generally, and that is going to affect people's ability to enforce their human rights as much as anything else, although probably it's right to say that it's an area which may be slightly less badly affected than others because of the availability of legal aid. But as to whether it's been effective, I think it has. I mentioned in my first answer that public authorities are more respectful. But in addition to that, if you look at the early cases, I mean, there are lots about things of how children should be treated in foster care, whether elderly couples should be separated and put in different care homes against their wishes. I mean, things that you would now, I mean, I think our eyes would pop out of our head just reflecting that some of these things were being done in a rather cavalier fashion that was happening right up until the 1990s. And when you look at that, I think that's when you start to realize that rather than what I would call the high profile cases, people are in fact being enabled to assert rights, usually when it's public authorities who are bullying them into doing something which is wrong or disregarding their gender, their sexual orientation. And these are all areas which we now rather take for granted, should be taken properly into account, but all very often came via some court cases which laid down the benchmarks. So to that extent, I actually think it's been very effective. It strikes me that it will continue to be so as society changes. And from that point of view, it's been very beneficial.
Oh, thank you. I appreciate that full answer. I suppose the lead on from there then is really about getting the balance right. And if I may come to you again, Mr. Grieve, first on this, do you think that the Human Rights Act strikes the right balance currently between enabling individuals to enforce their rights and in balance with effective government? And in particular, I'd just be really interested in your views around whether the enforcement of rights under the Human Rights Act could actually be improved upon. Where are areas that it could be made better than it currently is?
It could be speeded up, but that's something which you could always ask for. Justice in this country and in most countries is very slow, and that is a measure of its care, but sometimes the length of time must be a source of anxiety. That's the thing which I worry about the most. And accessibility, although, as I say, actually human rights claims tend to have the necessary support for them to be brought. And effective government. I had 4 years as Attorney General. Did I ever feel in my 4 years and whatever, a few months as Attorney General, that government was being rendered ineffective by Human Rights Act claims? No, I didn't. Of course, it can sometimes be irksome, and there is a cost to government. There's no point in escaping that. Government is a major litigator, and the government legal service has to handle a great deal of work. But when you actually factor that against the government's total expenditure, it's a drop in the ocean. And while I used to have ministerial colleagues who understandably were sometimes irritated by some of the consequences of judgments or indeed the litigation that was surrounding it, it's a question I think you have to ask, is this a price worth paying for trying to maintain the standards which are contained in the convention? Now, obviously, and we may well come on to this later on, occasionally there are decisions where politicians feel the courts have gone too far, or the courts are applying the law in a way which they don't think is justified, or intruding into areas of policy making that they don't think is appropriate. But the point I think I'm trying to make is that you've got to balance that out against what I would call the ordinary human rights litigation which is taking place, which I think ultimately leads to better government decision making. Shouldn't be seen as adversarial. It is part of that coming together of a process in a democratic society by which you try to improve the standards of governance. And an adverse court decision, as I always used to say to my colleagues, is actually helpful, or should be seen as being something to help better governance, not being seen as an impediment to it.
No, thank you. And same question to you, Lord Neuberger. I'll repeat it so that it's fresh in your mind. So I just wanted to get a sense of whether the Human Rights Act strikes the right balance between enabling individuals to enforce their rights and with effective government, but in particular, whether there are areas within the Human Rights Act that potentially could be improved upon, especially around enforcement of rights.
Again, I rather boringly, I'm afraid, find myself in agreement very much with what Dominic Grieve has said. I think what I would say about unpopular or criticised court decisions on human rights is this. When you refer issues to court, it's often, particularly if they're high profile and go to on appeal, they're often involve difficult points. And there will always be disagreement about difficult points, sometimes quite strong disagreement. Also, there will be times when the courts get a decision wrong. I know I've got decisions wrong in my time, and any judge who thinks that he or she has never got a decision wrong isn't fit to be a judge, because we all make mistakes. And the danger is that the controversial decisions on which people can strongly disagree, or the odd decision where the court's got it wrong, get very strong headlines and often very critical headlines, and can give a very distorted picture of the operation of the Human Rights Act, which, as Dominic Grieve has said, operates normally at a much less high profile level in relation to people going about their business and daily lives, both on a personal level and on a commercial and administrative level. And one doesn't see the results, and even if they're court cases, you don't read about them. How things could be improved, I think that the main point that's got to be made is the one that Dominic Grieve has made about the difficulty of getting to court and the delays. And as he rightly says, and if I gave an opposite impression, I should correct it, legal aid is generally available, unusually in a civil area, for human rights claims. And to that extent, they are better served than others. Apart from that, I think that an important aspect, if it can be achieved satisfactorily, is communications between the various branches of government on a relatively general level, so that judges can appreciate what the executive's concerns are and what Parliament's concerns are. Obviously, discussing individual cases is inappropriate, but mutual understanding could have its advantages. And if the courts are getting things wrong and there are areas where they're deciding cases in a way which makes government difficult, and like Dominic, I'm unaware of any such cases, then A, that's something that the judges should be told in open court about the problem so they can take them into account. And B, ultimately, if there is a problem that can't be solved in court, Parliament is the last word under our system. Parliament can change the law. But at the moment, at the risk of being accused of being complacent and willing, as I am, to think about other possibilities, I think the system's working pretty well.
Thank you, Chair. So there are sort of two parts to it, really, but the first is around practicalities again. So firstly, does the obligation on courts to give effect to legislation in a way that is compatible with convention rights, so far as it's possible to do so, of course, cause any problems in practice? And similar to the last question, really, could you give any examples where courts have been given an unduly strained interpretation to legislation in order to read it compatibly with the convention? Perhaps to Lord Neuberger first, if that's okay.
I think that the idea of the declaration of incompatibility, as we've discussed, is a very elegant way of getting the courts to be free to do their job of deciding whether a statute is inconsistent with human rights, but then paying proper regard to parliamentary sovereignty by saying over to Parliament to decide what to do about it. Picking up Lord Singh's point, it demonstrates both the rule of law with the courts deciding the point of law and parliamentary sovereignty with Parliament deciding what to do about it very well. It could be said to be slightly cumbersome, but actually it has worked very well, and only in relation, as far as I'm aware, to prisoners' votes has Parliament not reacted appropriately to what the courts have decided.
And thank you. And with regards to that, so if I may stick with you for the moment, Lord Neuberger, and then I'll come over to Mr. Greed. Do you think that the mechanism provided by Section 4 of the Human Rights Act, whereby the courts can give declarations of incompatibility but not strike down primary legislation, is effective in maintaining parliamentary sovereignty?
Yes, I think it is, because what it means is that the courts can't undermine or reverse a statute passed by Parliament. What they can do is to pass the baton back to Parliament and say, look, we don't think this complies with the Human Rights Act. And having got the benefit of a judgment explaining why, Parliament can decide, hopefully, that they will change the law, and can also decide precisely how to change the law. They may decide, having read the judgment, they can tweak it very slightly and that's all they want to do, or they can decide on a much more substantial change, but that's up to Parliament, not the judges. As for the judges reading down a statute, I was, in anticipation of this interview, I was looking at a few cases, and I think there's quite an interesting one in 2004 in the House of Lords, as it then was, where the House had to decide whether a provision in the Rent Acts enabling somebody's wife or husband to succeed to a tenancy where the person concerned had died. And 4 members of the House of Lords decided that they could read wife or husband as meaning a person of the same sex. But Lord Millett, who dissented, said this: mathematically, there are 4 possibilities: his wife, her husband, and his husband. And then he said this: 2 of these are nonsense. A man cannot have a husband, and a woman cannot have a wife. So he dissented, and that was a difficult decision in those days. But what it illustrates is a point that Dominic Grieve made very well earlier, that the idea that a man couldn't have a husband and a woman couldn't have a wife were obvious to a very eminent law lord 15 years ago. And today, we now treat it as completely acceptable. And indeed, to say otherwise is thought to be unacceptable. And I think the Human Rights Act and the philosophy and thoughts and decency it has engendered has a lot to do with that very significant change over such a short period.
Thank you. It's an excellent example that you've given there, if you don't mind me saying. Thank you. And if I may ask you, Mr. Grieve, the same question. Let me know if you want me to repeat it, because I know it's rather long.
No, I think I got the gist of it. Again, I find myself in agreement with Lord Neuberger. I think, again, that if you look at the sort of cases where, generally speaking, including the one that we were just looking at, which, funnily enough, had sprung to my mind before this hearing, so I'd made a note of it, of reading down, I suspect that the majority, I don't know, it's speculation, but the majority of the House of Lords in that case were probably aware of, even then, the extent of the societal changes that were taking place in this area and were already reflected in other legislation that was being enacted by Parliament, which had equality, and therefore, for those reasons, felt able to read down. I think it was Baroness Hale who once said of, quite outside the Human Rights Act, statutes are always speaking. And the way you would interpret a statute in the 1920s can be reinterpreted to mean something different, to apply it differently in the 2000s. So I think most of them are explicable in those terms. And it's also worth bearing in mind the occasions when the court's been unwilling to do it. I mean, I was thinking of R.V. Anderson, which was a case which was about the Home Secretary's right to override the parole board in respect of the tariff for the life sentence. And it was at a time when this was shifting. And the court correctly said that this was in fact in breach of the convention, but there was then Lord Bingham was absolutely clear in his judgment that the court should make a declaration of incompatibility because this was a matter that had to go back to Parliament because of the awareness and sensitivity that if it was dealt with by the judges just saying they were going to read the statute differently, this would lead to a serious sense of irritation at the parliamentary level that this had simply been brushed under the carpet. So I think there are some good examples there of where the courts have been quite reticent. And as I say, it may be that I've missed an example. I'm not encyclopedic on this. And it could be that somebody will come up with an example where they think that the read down was wholly unjustified. But actually, most of the read down seem to me to have a very clear explanation behind them.
Thank you.